and we are here considering a number of bills. There are two in a voting session. Okay. Two bills for a consent calendar. They're both withdrawn. There's a motion and a second to vote unfavorable withdrawn on 975 and 1017. There's a motion and a second. Any discussion? Seeing none, all in favor of the unfavorable withdrawn on both bills, please say aye. Aye. Anyone no? The motion's adopted. They're unfavorable withdrawn. Here's what we're going to do. We're going to start this evening with House Bill 824, which is legislation that has to do with concealed carry and the Bruin decision. It's the last one on the list. And I understand that my friends who are perhaps concerned about the bill would perhaps want some more time till tomorrow. We'll see how we do in the discussion here. If they reconsider, that'd be fine with me, but, a guy can dream. Having said that, I think that members of the committee are familiar with what is in the bill, but I'm happy to go through the bill and just kind of go from beginning to end, along with a couple of amendments that we may offer when we actually vote on the legislation, whether that's tonight or tomorrow. The legislation, it starts with changing some of the rules for when you can get a handgun qualification permit, by saying that if you are on supervised probation after being convicted of a crime punishable by a year or more, or for a violation of 21902B or C of the transportation article, those two are 60-day maximum penalties, although sometimes there's a subsequent offender for DUI. They're driving while impaired or driving under the influence of drugs or alcohol. Or 3, violating a protective order under 4509 of the Family Law article. It also indicates that you could not possess a gun if a regulated firearm if you have been convicted of a second or subsequent violation of 4104 of the Criminal Law article, and that is the existing storage statute. So again, I'm just going to roll through the bill as it's drafted and then mention amendments at the end, or potential amendments at the end. The bill says, with regard to the storage component, does two things with regard to storage. One, well, really 3. If you're convicted of the current storage statute, which is right at the front of the bill, it's 4104 of the criminal law article. You're convicted and no one is hurt or killed, you would lose the ability to possess a firearm and lose the ability to carry for 5 years. If you were convicted a second time of failing to abide, or you were convicted a second time of the storage law, you would not be able to possess a regulated firearm. If on the first time a person was convicted of the storage law and somebody died or suffered a serious bodily injury, they would also be permanently banned from possession of a regulated firearm. So that's that part of the bill. I'm going to keep. If somebody dies as a result, there's a conviction for failing to abide by the storage law as it exists right now, and as part of that, someone dies or suffers a serious bodily injury, then the person who violated the storage law would be banned from possessing a regulated firearm. For the purposes, so that everyone knows, a regulated firearm is basically a handgun. Does not include long guns and shotguns. And Delegate Conaway has a question, so I'll stop.
That's as long as the gun is not reported stolen.
If the gun were reported stolen, they wouldn't be able to be. They may not be able to be convicted, and that would be a choice that the state's attorney would have to have. But if the gun were reported stolen, that would have some bearing on whether or not they violated the storage statute.
And so if the gun was reported stolen, but they were convicted or were potentially accused of violating the storage part, I mean, they say where was the gun? Where did the gun get stolen from? Off the dresser where I leave it when I go to work.
And the person then reported it stolen.
Yes.
Then they would have reported it as having been stolen. I guess the question still comes back to the existing storage law, which says that you can be found guilty of failing to properly store your firearm. I'm going to give the exact language. A person may not store or leave a loaded firearm in a location where the person knew or should have known that an unsupervised child would gain access to the firearm. So if the gun were stolen by somebody other than a child, then this wouldn't be, that it may not be an issue, but it's a question of whether they knew or should have known.
What's the age of child?
The age of child under the law right now is 16.
Thank you.
Okay. All right. I'm going to keep going through the bill. It raises the fee from $75 to $150 for an initial application, $50 to $100 for a renewal or a subsequent application, or $20 for a duplicate or modified permit. We contacted the state police. We also got more information regarding how much the licensing division has effectively costs over, and I, of course, have mislaid that piece of paper. And we, right, so we found that in fiscal well, okay, but what I need is this one. There we go. So in fiscal 19, the amount that was received from both the handgun qualification permit and the existing wear carry fee in fiscal 19 was $2.5 million. The licensing division of the Maryland State Police cost $10.6 million. In fiscal 20, the fees raised $3.5 million. The licensing division of the Maryland State Police cost $11.1 million. In fiscal 21, the fees raised $6.4 million. The cost of the licensing division was $16 million. In fiscal 22, the amount raised was $4.3 million. The amount that the licensing division cost was $15.7 million. And now in fiscal 23 through the end of January, remember fiscal 23 goes from July of 22 to June of 23. So far, they have raised $9.6 million and spent $20.8 million, as I understand it. The fiscal note indicates that the amount of revenue that would be raised under the bill as it is currently drafted is $8 million. So in every case, at least for the last 5 or 4.5 fiscal years, the amount that would be raised is actually still under the cost of the licensing. That was an issue that was raised, and it was raised in the testimony here, and was raised as a constitutional issue. I believe that we're demonstrating that there's clearly a gap there that still even remains, even with an increase in the fee. Having said that, one of the amendments that I am going to offer will lower the amount of revenue that will come in changing the length of time that you can, currently it's a renewal is good for 3 years. The bill says it would be 2. An amendment would take it back to 3. That would mean there would be less revenue coming in from the license renewal fees, and also probably a lower cost in the operations of the licensing. Anybody who wants to talk about the fee? Delegate Tolles.
Just a general question, and I'm sorry, it may or may not be related. Just do the revenues that come from the fees is only used for operational purposes? It's not like how you use a fee for victim rights or some other issue like that.
The fees are actually, they go to the general fund.
Okay.
So the fees go to the general fund. The state police are funded through the general fund as well. So there's not a specific fund where the fees go into and then come out in the licensing division. So there's not.
Like a portion used for something else.
I don't believe so, no.
Okay. Okay.
Delegate Taylor.
Constituent who was really concerned about the going from 3 years to 2 years. So I think there was a lot of feedback from our residents that said they really liked the 3. If they would appreciate if you kept the 3
If
years.
it went back to the 3 years.
Went back to 3 years, yeah.
Well, okay.
Don't twist my arm.
So there's that. Let me go on here. Yeah, Delegate Munoz, I'm sorry. We're getting there someday. Eh.
You got Kim again.
There she is.
Thank you, Mr. Chair. I just want to say, like Delegate Taylor expressed, I've had a lot of people reach out with concerns over the time period between the permits as well as the overall price. And I've said repeatedly, I've been concerned that increasing the price is going to make people who are unable to afford these permits into criminals. And that's absolutely, I think, the last thing any of us want. So I just want to thank the chair for this amendment, and I really appreciate the flexibility.
Okay, thank you. I'm going to keep going. There are other things that are added to the requirements for the wear and carry permit that's in the bill as it stands. Again, as I mentioned before, if a person is on supervised probation for a crime that carries more than a year, or they're on probation for driving while impaired or driving under the influence of drugs or alcohol, or they violated a protective order, they wouldn't be able to get a wear and carry permit either. It moves the language from the, there's existing language that restricts people who suffer from a mental disorder. This language was taken from the qualifications for the handgun permit. It's also now, it would also live also in the wear and carry permit, and say that a person cannot have been involuntarily admitted for more than 30 days to a facility as defined, to a mental health facility. It also says that you cannot receive a wear and carry permit if a person is a respondent. In other words, a person who has been identified as the person at issue in an extreme risk protective order or a red flag order, or an ex parte protective order. This is not a peace order. There is a difference. A protective order requires more of a long-term relationship. A peace order does not. It also indicates that any other type of current court order that may be in place that restricts a person from purchasing or possessing firearms, they would not be able to have a wear and carry permit. The class that they have to take to get the wear carry permit would change to include classroom instruction on state and federal laws with regard to firearms. It would include state self-defense law, and while that is not defined, that would be deferred to the state police to be able to identify what would be included in that. But at the same time, it would talk, and we've talked a lot about this in this committee in the context of the police reform debate, but talk about when force is justified, the justifiable use of force or deadly force, or the proportional use of force in self-defense and conflict de-escalation and resolution. It changes the language with regard to the live fire requirement, where before it said that it would be a firearms qualification component that demonstrates the applicant's proficiency in use of the firearm. It changes it to say a firearms qualification component that includes live fire shooting exercises on a firing range and requires the applicant to demonstrate safe handling of a handgun and shooting proficiency with a handgun. So I'll stop here and see if anyone has any questions with regard to those further requirements for the wear carry or for the class. Delegate Eric.
Thank you, Mr. Chair. I'm just want to know about the ERPO and the other things. That's for current ones, right? It's not like there was an ERPO and then it was, processed through the system and now it's been removed. Those people are now eligible again.
They would be eligible again. It would be during the life of however long that
Right.
ERPO lasted
Right.
and however long the protective order lasted,
So
which
if-
generally would be, in the case of a protective order, usually about a year.
Okay, so yeah, so I can't apply while any of those are in place.
Correct.
Okay, understood.
That-
'Cause
yeah, it
you
says-
can't get a gun
It
during
says a
that time
current
period anyways.
protective order and a
Right.
current
Yeah,
ERPO.
that's what I just wanted to confirm. Thanks.
Delegate Valentine.
Thank you, Mr. Chair. And I believe I may have just had my question answered because I'm a couple of pages behind with regards to the prohibitors for the 21902 section. Is that again also fluid only as they're on probation and then that would go away once their probation is completed?
Correct. It would
Okay.
go away once the probation is done. Probation, there's already existing language with regard to, it's called under the law a habitual drunkard, which is also
That's-
defined under the law,
Yes.
which I won't make light of it, but it is kind of fantastic language. Having said that, it extends the period of time that someone would be prohibited by extending it effectively by the length of time that they were on probation. So in district court, you can be on probation for up to 3 years. In circuit court, you can be on probation up to 5. Delegate Kaufman.
Let me preface my question by saying, Mr. Chair, I'll be proud to vote for your legislation, and I hope we do so this evening because it will pass. But my question, my question is this, Mr. Chair: when you're talking about mental health disorders, can you talk about what conditions you're referring to, and whether or not it makes a difference if somebody's on their meds and doing what they're supposed to be doing? Can they, if they're taking their Xanax or whatever it is, can they still get a gun?
Well, first of all, it would be an involuntary admission. So it would not be a voluntary admission. This was part of a debate that has kind of sprung up from time to time in this committee, came up during the gun bill in 2013 about how far should that go. And so the idea here that it is an involuntary admission and what kind of conditions, I'd have to refer you to the section of the mental health, to the mental health article that covers those.
Okay, well, I'm just curious. So this, just to make sure I understood what you said, this would be, so therefore, it would only impact, I'm just using her because I know her, she's a friend, it would only impact John or Jane Doe if a Judge Dumais says you got to go and get treatment, like if a judge orders you to get treatment.
If you were involuntarily admitted, and there's a process by which you can be involved, it sometimes could involve a judge, I think sometimes it doesn't involve a judge. You can where you're involuntarily admitted into a facility, yes.
And it's for more than 30 days.
It's for more than 30 days. And that is existing law and an existing prohibitor for people who seek to purchase a handgun in the first place.
So it's nothing new. Okay, thank you.
This just moves, it copies it and puts it in the wear carry section as well. Right, I already talked about the storage. It adds, the bill adds language saying that the secretary shall revoke a permit on a finding that the holder doesn't meet the qualifications. Is there in the bill. It also asks the Secretary of the State Police to review information regularly regarding active permit holders to make sure that they're continuing to meet the qualifications under the wear carry law. It says that the Secretary may revoke a permit on a finding that the holder violated a specific subsection of the subtitle, and I'd need to look up 308 because I've just forgotten exactly what it is all of a sudden, and I'm becoming old. But I'll come back to that in a second. We're all becoming old. Sorry. If the secretary revokes a permit under the section, the secretary, because they determine a person is prohibited from possessing a regular firearm, the Secretary shall take reasonable steps to ensure the surrender of any regulated firearms in the person's possession. There's existing law that deals with how that happens. If the Secretary denies a permit, the Secretary has to provide written notice of that initial action to the applicant, including a detailed explanation of the reason or reasons for the initial action. And interestingly, just not to go too far into stories about my past, but one of the first bills we heard back in 2011 was a bill related to concealed carry permits, and one of the issues was that people didn't actually know why they were not allowed to get the permit. So this requires the state police to provide that information. The written notice shall include a detailed explanation for why. It also has some data collection requirements, including the total number of permit applications that were submitted to the Secretary within the previous year, broken down by county in which the applicants reside, as well as the race, age, and gender of the applicants, the total number of permit applications that were granted again broken down in the same categories, the number that were denied, and the number that were revoked. And then the total number of permit applications that were filed with the Secretary that were pending at the issuance of the report, broken down again by county, race, age, county, and then race, age, and gender within the county. That's the bill as it was drafted. I mentioned one amendment that would again require that would allow for the renewal to be every 3 years as opposed to 2. There are 2 other amendments that the chair is going to offer. One of them relates back to Delegate Bartlett's storage bill, and one of the parts of Delegate Bartlett's storage bill would change the age. Delegate Conaway a moment ago asked how old a child was in that definition. Under the existing law, that age is 16. I would offer an amendment to make that 18. There would be a second amendment related to the storage section that would, so it would be anyone under 18 as opposed to anyone under 16. The second part goes to another part of Delegate Bartlett's bill that requires the creation of a pamphlet with regard to youth suicide that was part of her legislation. There was also a grant fund that was established in her legislation. I can't help you with the grant fund, Delegate Bartlett, but we can help with the pamphlet. So there would be money set aside for pamphlet and more information related to youth suicide. Having said that, those would be amendments that I would offer. I suspect there will be other amendments, but let's take questions now and we'll go from there. Delegate Conaway starts.
Thank you, Mr. Chairman. So why would you be suggesting to amend the bill from 16 to 18?
I'd be suggesting to change it from 16 to 18 because, again, I think the issue goes back to the reason for the storage law in the first place. It tends to address issues related to particularly youth suicide, and I myself don't see a compelling reason to not include effectively 16 and 17-year-olds under the ambit of that storage bill.
Can you say that a different way? Yeah, you said.
I'm really bad at Pig Latin this time of night, so yeah. No, I'm sorry. I think that it's important to cover 16 and 17-year-olds under the storage statute, and that's what it would do.
So therefore, you're saying that a 16 or 17-year-old, regardless of the testimony we heard about this brain development, doesn't know that they shouldn't take a gun and put it to their head just because it's sitting out or something like that?
What the law says right now is that a person may not store or leave a loaded firearm in a location where the person knew or should have known that an unsupervised child would gain access to the firearm. What I would amend that to is that an unsupervised minor would gain access to the firearm. So my argument is it should cover all minors. It shouldn't stop at the 16.
So in other words, let me come at this a different kind of way, because I don't want you to think I'm just playing with you. So
I think you're
if my
fine with
dad thinks I'm responsible enough to have my own car when I'm 15 and a half, and which I had, and I drove every day, which I did, and I had my own job, which I did, and I had my own money. So I had my own car. I'm at 16, 17, and 18, I'm not responsible enough to know that I shouldn't take a gun that's sitting out or is sitting where the gun stays and blow my own head off unless that's what I'm trying to do.
I think what the bill, what the amendment would seek to do, and what the law currently says, and what the law would change is that we don't want a person to leave a loaded firearm in a place where a minor can get a hold of it.
Yeah, I see you, but we are, and what the amendment is attempting to do is to change the age definition of the minor, right?
No, what's in the law right now is it says child, and it defines child for the purposes of that.
And we
Well, the
would
storage
change
law
it.
is 16, it would turn it to 18, effectively by making it.
Thank you, Mr. Chair.
Delegate Young, and I see Delegate Erican. Oh, I'm sorry, and Delegate Souls.
So I just want to be clear, a properly stored weapon, not loaded, storage is correct, but my 17-year-old knows how to access that weapon, does access that weapon. Would that, would I be potentially in danger of being criminalized?
What the state would have to prove is that the person who was accused of the crime would have stored or left a loaded firearm. So if they can't prove that it was stored loaded, then they can't make the charge under the storage law. So to your point, if there's evidence that the weapon was not loaded and it was stored properly, that would result in a conviction. It could possibly still result in a charge, and that's an issue where we can enter that chicken and egg debate for the next 4 hours, and that'll be great. But having said that, here comes Delegate Erican, because I suspect that's where we're going to go next.
Oh, you cleared up for me, though. Thank you.
Thank you. Delegate Erican, hi.
I love this new system, you guys. Okay, so yeah, that's the chicken and egg scenario. Just kidding. All right, let's just say you have a kid that you leave at home to babysit, and your other kids, and somebody breaks into the house armed, and your child does gain access to a gun and shoots in self-defense, which has actually happened in the last couple of years in a few different places. Is the parent still going to be prosecuted under the new language?
And as we get into this, and we've had this debate before, and I'm sorry to start it with that, because there are a lot of new people on the committee, and they don't know that we've had the debates before.
Yeah.
So I'm sorry, but it will
Don't apologize to
depend
me,
on
I've
the
heard it.
facts. No, it'll depend on the facts that are brought before the state's attorney, and the state's attorney is going to have discretion to decide whether this happened because because the parent left the gun in a place that the child, or under my amendment, a minor could use it, could find it, and not necessarily even use it, just gain access to it. That, I think you'd have a state's attorney who said, okay, here's somebody who broke into the house. You're possibly dealing with a different set of facts there. What the storage law seeks to prevent is, honestly, there's a case in Baltimore City right now where a 9-year-old found a gun that was left, I think, effectively on the kitchen table. If I'm remembering properly, it was loaded, and they took it outside and they shot a 15-year-old in the head.
Right.
I mean, and State's Attorney Bates is going forward on 2 counts of violating the storage law based on that set of facts.
Yeah.
That is more likely going to be the set of facts that we're looking at for the storage law.
Right, and so.
And for what it's worth, the existing penalty under the storage law is $1,000. So this puts some teeth behind it.
Okay, so right now he is prosecuting her for this. So, but you're saying it's
prosecuting yes.
and what's she looking at? Like,
2 $1,000 fines for that. I
That's
think
it.
she may be charged with other things. I don't remember the other things she's charged with.
Like child
but-
endangerment, things like that.
Perhaps, but I don't remember that part of it. I know that he's bringing 2 counts. He was bringing 2 counts under the storage law, which carries, again,
Okay, so the
to-
parent in any situation could be charged. It's going to be up to the discretion of the state's attorney,
up
which
to the discretion of the
in
state's attorney.
different districts could look very different, just for the body to think about.
Maybe. Delegate Tolles, Delegate Taylor, Delegate Schmidt.
Thank you, Mr. Chair. Just, real quick, I do think that the education piece is important. That is in some of the recommendations from Delegate Bartlett's bill, but, you know, in conversing, recognizing that. So I was wondering if some of those fees could be used for the education piece, but, you know, may not be something we could do now. I know there's an issue with money and stuff, but if there is a conversation that comes up, perhaps at some point, you know, with the probes and the money and all that, I think some of those fees could be used for education purposes if it won't, you know, impact the bill negatively, even if it's like a small amount. Thank you.
So, and I appreciate that. What my understanding of the constitutional standard, and there's a constitutional issue here, because this is a fee related to the right to bear arms. So it needs to be direct. You have to have some kind of causal connection between the fee and the cost to run the licensing division. And I think that there are examples in the past where the Supreme Court hasn't looked kindly on directing fee money that's paid specifically towards licensing being redirected to something else. So the idea is that the fee is to cover the effectively the state's costs in covering in paying for the licensing division.
Sorry. To that point, if it was like, so to do like a pamphlet as you're doing your licensing, something to say, you know, like how do you obtain a license and a process for that, some type of caveat in that wouldn't be able to be included on that particular educational piece because it's not fully part of the operational dynamics of.
I mean, I think it could be paid for the general fund, which is effectively what would happen with the pamphlet as proposed by Delegate Bartlett.
Okay.
So that could be paid for separately. I think, again, when you get into questions about where that money is specifically sent to, that's when you run into constitutional issues.
Okay, thank you.
Delegate Taylor, then Delegate Schmidt, then Delegate Munoz.
Actually, Delegate Ercan asked my question, but I have a procedural question. Just because I'm a freshman and I'm not sure how this works.
Sure.
If we vote this out today, you said that there may be amendments forthcoming. So there's an
Well, normally on a bill like this, which tends to be one of the bigger bills that we deal with, we will we'll bring the bill out. We'll let everybody. We'll walk it through, which I've done. We've started to talk about amendments. If people want to go forward and start taking up amendments and doing whatever, we can do that and move and in the committee, and we can do that right here, and we can start doing that tonight if you want. Traditionally, I will tend to look at, especially on this issue, and just saying, I will start to look at my Republican friends and just say, do you want time to put together amendments for tomorrow? They might not, and I will. Okay, but I will defer to them. It's a process, and I'm just trying to be respectful to everybody so that everybody has the chance to do what they would like to do within reason. Delegate Schmidt, then Munoz.
How would this relate to the incident that occurred in the middle school on Fort Meade that we've referenced a couple different times in committee, where the 13-year-old brought the loaded handgun and then there wasn't a charge brought against the parents? Does this allow that?
Well, that's existing law. So the question would be, and it's one that okay, so I have a job at the Anne Arundel County State's Attorney's Office, and so I'm going to stop fairly short of the answer that I think you want. But that would be a decision effectively for the Anne Arundel County Police Department, and as to whether they would bring a charge and whether they could prove or not whether or not the gun was properly stored. Nothing in this bill changes the existing storage law, except potentially the amendment I mentioned that would extend it for kids 16 and under to 18 and under. So under 18, I'm sorry. And so that's a imperfect answer to the question, but I don't know what investigation they did and whether that
Something's
statute,
pending or
whether it could have been or whether there is something pending. So I don't really want to go too much further, but they may be able to charge under that. But again, I don't know the specific facts of what happened and how the child got the gun in that case.
Okay, thank you.
All right. Delegate Munoz, then Delegate Williams.
Thank you, Mr. Chair. So this is an interesting amendment, and I just have a couple of questions because, as I mentioned in HGO, I'm very proud to have this ribbon on today celebrating my not one but two parents who are military veterans. And my father was actually removed from a home where he was abused into a foster home. And at the age of 17, he was able to go into the military. And so that's my question with this change in the age. I mean, we're sending young men and women off to serve in the U.S. military at the age of 17, go to boot camp, go to war. And so would this affect those people and their opportunities?
So there are two parts to the answer. One, there's nothing in the bill that changes the existing law with the ability to get a regulated firearm if you are a member of the armed services. You said page 7. Page 7. Oops. Right. Well, there are two parts of this. First of all, there's the HQL, which has an allowance for somebody who is in the military, but also if in the bill it says that a wear carry permit would be for people who are 21 years and older, but it exempts people who is an adult who is a member of the armed forces of the United States or the National Guard. So would it impact somebody who is 17 and that? No, they would not be covered by the wear carry permit, but when they turned 18, they would be able to get the wear carry.
So a 17-year-old.
A 17-year-old member of the military, at least as it's drafted right now, would not be able to do that. But if you would like to consider something that would allow the change from just simply being an adult to just someone who is a member of the United States Armed Forces or National Guard, I'd certainly entertain that.
Okay, that's that's a concern with the military piece because we find these people mature enough to be in that position. But I'm also concerned about, we've had discussions about our police force and security guards and so many other people that we are missing bodies for. And to Delegate Arakan's issue, if my father at 17 was responsible enough to have a gun put in his hands and protect our country, is my oldest son, if someone comes into our home to harm us, is he not then also able to go and protect his siblings or something like that?
So there are two. There are a couple different issues here. First of all, your oldest son is 17, or
not now.
Not now.
But one day he will.
One day. Okay. I mean, again, this does say that they would have to be 21 to have a concealed carry permit, a wear carry permit.
Mm-hmm, mm-hmm.
If the issue is with regard, what I've heard you saying, or are you talking more on the storage side?
Yeah, I'm talking like
Yeah.
in case of a home intrusion or something like that.
Again,
And he has 4 young siblings, and he's the oldest, and he's the only one home.
I understand that. I think it's a question of the state's attorney's ability to decide whether or not in that set of circumstances the person got the gun because it was improperly stored, or the person got the gun because there was an emergency and somebody broke into the house and was threatening the kids.
Okay.
One thing would fit under the proper storage law. The other, I think, would be a little challenging to fit, I believe, under the storage law.
So then to kind of combine those two scenarios, if we had, all the proper storage aspects in place, we have the education, because that's very important to me, that people are educated and know how to protect themselves, and we have suicide prevention. But if my 17-year-old is incredibly responsible and watching over his younger siblings, and we say, unless someone's life is at stake, you do not go into these storage units. If you're literally, your life, your siblings' lives are under threat, you have access to the firearms, the ammunition, and that is the only case in which you have permission to go there and get that. How
So
would that be covered under this bill?
The other part of the storage law that's not actually printed in the bill and that I left out was the exceptions. If the child's access to the firearm was supervised by an individual at least 18 years old, but to your point, the child's access to a firearm was obtained as a result of an unlawful entry, then the storage law does not apply. So if somebody breaks into the house, then the storage law would not apply in that circumstance. Or if the firearm is in the possession or control of a law enforcement officer while the officer is engaged in their official duties. Again, so if they're a police officer, then they are they are in control of the firearm, then the storage law wouldn't apply. It also allows, if the child has a certificate of firearm and hunter safety issued under the natural resources article, then the storage law would not apply in that case either if the child had applied for that.
What age would that be effective? Any minor who has that training.
Yeah, it would be minors who had that training.
Okay, thank you.
Yes. Delegate Simpson. Oh, I'm sorry, Delegate Williams, then Delegate Simpson. It's my fault. Delegate Williams.
Actually, Mr. Chair, I turned my button off because actually I was about to ask about the training under the natural resources article. I swear to God, every year I end up in the natural resources article for something, which is so strange to me. But so anyway, but you answered my question about the natural resources article. If someone is a minor and they attain that certification, then it would be fine. And so I'm okay now.
So are we at the point, like, with having questions, or does anybody have amendments, or do they need time? I mean,
so at this point, I'm not sure. I'm happy to hear people, if the will of the committee is to hold on and to vote this tomorrow and request further amendments, I'm fine to do that. We would ask that the committee receive those amendments prior to a voting session, which I will say we would want to try and have prior to our bill hearings tomorrow, unless you want to come after the bill hearings tomorrow. And we are all experiencing how exciting this can be, but it's up to you. But I'm going to defer to the will of the committee, and I don't want to. We don't necessarily need to rush, but we do. But I would like to get this moving, and again, I'd like to get it moving for the bigger picture, because we need to change our laws related to concealed carry because of the Supreme Court's decision. So is anybody offering? You want to go? All right. So what I'm going to do is I'm going to ask for amendments to be distributed to the committee. We're going to go ahead now and we'll deal with different amendments. They have them already?
Sent them out to everybody.
So you have them? We can do that on the fly. But it's already there, actually. You can do the adult one. All right, we'll talk about that one last, but we can do that.
Okay. Is it okay if I move?
So the first amendment that I'm going to offer to the bill would be, so you okay? All right. The first amendment I would offer to the bill, it has at the top 923-620/1. This would change the renewal period back to 3 years from 2. There's a motion to accept the amendment and a second. Is there discussion on the amendment that would set the renewal period back to 3 years from 2? Any discussion? All in favor of the amendment, please raise your hands. Thank you, David. 1, 2, 3, 4, 5, 6, 7, 8, 9. Anyone opposed? The amendment's adopted. All right. Number 1. Amendment number 2. It would do 2 things. It would create a guide. It would create a guide, which is the Youth Suicide Prevention and Firearm Safe Storage Guide, developed under the statute on or before January 1st, 2024. I'm sorry, the number here is 523823. The Deputy Secretary for Public Health Services would develop a Youth Suicide Prevention and Firearm Safe Storage Guide. It would be developed under subsection B of the bill, which talks about the guide. It would provide a description of requirements under the storage law, identify the risks associated with unsafe firearm storage for minors, including suicide, death or serious bodily injury from accidental discharge, and shooting incidents involving minors, and incorporate best practices for firearm and ammunition storage. The department would have to post it on their website, make an electronic version of the guide available to families, health, and social service providers, and any other entities that have an interest in youth suicide prevention or firearms storage, including several different groups, including school systems, the health departments, the Department of Juvenile Services, behavioral health programs. It would allocate $50,000 to pay for. Oh, I'm sorry, no. It creates an advisory committee with that is used to design the pamphlet. We don't do the money here. Okay, they believe it will cost $50,000. There is not a $50,000 specific appropriation in the bill. No, this doesn't include the aids. This includes the pamphlet. This is just the pamphlet. Motion for a favorable is a second. Motion is a second. Questions? Conversation? Delegate Embry? No? You're just getting ready to raise your hand? Okay. I get that. I'm so excited. It's almost 10 o'clock, everybody. All right. There's a motion and a second, and seeing no further conversation. All in favor of the amendment, please raise your hands. Anybody opposed? Seeing none, it's adopted unanimously. Okay. All right. So we're going to do one part here, and then we're going to respond to Delegate Munoz here in a second. There are, do I do both? No, just the one. Okay. One, this is 353527. It would change under the storage law from child to minor. That would change it from under 16 to under 18. This does not address Delegate Munoz's issue with regard to somebody who is in the military who is not yet an adult. So we will make that, we will do an oral amendment for that right now, given where we are in the evening. There's
military, armed, and uniform service. There are differences.
Court's indulgence. It currently reads, is an adult who is a member of the Armed Forces of the United States or the National Guard. And uniform services?
Yeah, it is NOAA. My mom used to work for NOAA. They have a whole branch. There's also space.
Person under, remember, because someone under 21 and for those uniform services?
No, but NOAA is no. My mom worked for NOAA for 30 years.
With your mom
All right. We are, okay. Very exciting.
They're in my district. That's my district. I'm just.
All right. Delegate Crutchfield's very familiar with the uniformed services, and that's, so I greatly respect that. I think we're going to have to figure this out. Delegate Bartlett.
So I just want to make sure what this oral amendment could be. So currently we say at least 21 years old or is an adult who is a member of. So are we taking out the word adult to say is a member of, and then put in all the forces?
It would be is a person who is a member of the Armed Forces of the United States or the National Guard or the Uniformed Services. You need me to repeat that again? You got that? You got that? Does everybody got that before I take a question? All right, we'll go Grammer and then Munoz.
So this particular amendment is in regard to the age, or if you're a member of.
Right, we're gonna do one at a time. So let's do this one at a time. This will be the third amendment, and again, it's to 353527. Changes the storage law from impacting under 16 to under 18. So we're gonna do this amendment first, and then we're gonna deal with the uniform services and that one second, okay? Could I have there's a motion on the 16 to 18 amendment and a second. Okay, so that's fine. Question from Delegate Munoz.
Just to clarify, so in the event that someone under the age of 18, 21, so someone under the age of 18 accessed with parental permission a firearm and ammunition in the event of an emergency, this would not affect that situation?
That's what we discussed a moment ago. There is a carve out for a child who is acting in a situation, an emergency situation.
Okay, thank you.
Okay. Further on this amendment. Seeing none, there's a motion and a second. All in favor of this amendment changing the current storage law from 16 to 18, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. All opposed, please raise your hands. 1, 2, 3, 4, 5, 6, 7. The motion for the amendment is adopted. So that is that. So now we're on to the one we don't have a number for, but this is seeking to address the issue that Delegate Munoz raised. So it would say that a person, in order to get a wear-carry permit, would have to be at least 21 years old, or a person who is a member of the Armed Services of the United States, or the National Guard, or a member of the Uniformed Services. Everybody got that? Delegate Grammer. Actually, wait, could I have a motion on this amendment? Motion and a second. Thank you. Discussion. Now, Delegate Grammer.
So I'm one of the generation, I took my hunter safety course when I was 14. I was taught how to handle a gun and how to respect a gun. And we kind of came up on this issue when we had the smoking debate, and someone said, okay, we're going to lower the age of a person who can smoke to 18, and someone threw a fit about it and said, if you could get sent overseas, but you couldn't actually smoke, and that bill got amended. But I had a problem with the end result, because in the end, what happens is, if you're a member of certain, government employment, you actually have more freedoms than the average schmuck. And I am the average schmuck. I spent my Thursdays, 14, 15, 16, in the Marco Hunting and Fishing Club. We shot 22s at the range, and, when I was 16, I shot my first deer, and under this amendment, if you're just an average person, you have to wait till you're 21. But But if you're a government employee, you actually have a lot more freedoms. So I know it seems like a little thing to people, but I kind of object to the idea that certain people have more rights than others.
I think the argument and the reason that we carved this out was to, again, respect the fact that there are some people who are under 21 who are in the military. We wanted to seek to allow them to be able to apply for the wear carry permit. That's why we've created this carve out. I think the 21-year-old limit is appropriate, and that's why I've got it in the bill. Delegate Taylor.
Are we, with this language, are we accommodating those veterans, those that are honorably discharged? I think the language says are currently serving in, I think is what you said. So are we also saying that, are we including veterans and those that are?
What are they going to be?
Presuming they would be
They're
over
already-
21 when they were a veteran, I mean, I guess.
You could be honorably discharged.
It only covers the people who are presently members, who are members of the Armed Services or the National Guard or a member of the Uniformed Services. At least this amendment as it is written right
Yeah.
Delegate Young and then Williams.
Mr. Chair, so for the I want to just raise for folks who might be like in the cadet program at BPD prior to, they are shooting guns and things like that, getting trained. They can't take it home. I'll just double check with Delegate Valentine about kind of what the actions that they may take. Would we be open to potentially adding those individuals who are currently enrolled in those programs? No, they are 18 plus, but below 21. They are in the cadet program with the Baltimore Police Department. They are preparing to be a police officer. No.
If they're 18, they're covered.
What am I? It's 21 under this.
Oh, we're talking about the storage right now.
No, we're talking about.
Oh, we're not? Oh.
They're talking about is the wear carry permit.
Right.
They're talking about the wear carry permit and whether or not somebody who is in the cadet program at the Baltimore Police Department, who you said they don't take the gun home? Okay. I mean, that could be expansive. Let's go to Delegate Valentine because he's the one who appears to have.
Thank you, Mr. Chair. What I was relaying to Delegate Young was, you can be in a police academy, not a cadet, two different things. I'm sorry.
All right, thank you.
Okay, so in a police academy before you're 21, be firearms certified and all of that, and as long as you're 21 by the completion. So I don't think this would impact that because it's part of your training.
I don't think that we need to extend it to that. Delegate Munoz, then Tolles.
For the record, I would like to point out I have not asked any questions until this voting session today. I apologize, everyone. But
We're very proud.
I'm sorry. I'm looking at the current law, and so right now you must be at least 21 years old, but 18 years old for employment purposes only. And I just want to clarify this bill does not affect that.
That for the HQL, that for the handgun qualification license. This applies to the wear and carry permit.
Okay, so just to clarify, this is not.
Right.
Okay.
Right.
Thank you.
Delegate Arakan.
So I think she caught something though, because in order to be like a security guard, you do have to wear and carry a firearm. You don't just have an HQL. So are we cutting out security guards right now accidentally? Yeah. Yeah, 18, 19, 20. If there's already existing statute that speaks to that, it's probably because it happens. I mean, I would hate to cut them out for no reason.
I would say that I think that the 21-year-old standard is the right standard. I don't know how many security guards are 18 years old and are actually carrying firearms.
Okay, maybe we can. I'll see if I can find out. I feel like somebody came in on a bill a couple years back about this.
All right. So, Delegate Tolles.
I think I'm good. I was just going to say that training, when you're training for a police officer, you're covered under that. And I think that would include security too. They do some type of training, so I'm good. I would just piggyback.
I will say this. It is clear that it is likely that the Senate bill is going to look substantially different from what the House bill looks like. I would say that we're not done with this issue by any means of the imagination this session. So I'm very happy to commit, at least right now, that we'll take another look at that as this bill bounces back and forth. With that, there is an amendment, and I think did we have a motion and second on this amendment? All right, fine. So again, this is the amendment that reads as follows. Is a person, you would be able to get a wear carry permit if they are a person who is a member of the Armed Forces of the United States or the National Guard or a member of the Uniformed Services. Okay. All in favor of the amendment, raise your hands. Anybody opposed? Delegate Graham. All right. The amendment is adopted. We are on we've got the amendments. Are there further amendments? Seeing none, is there a motion on the bill as amended? Motion for a favorable and a second. Is there any final discussion on this bill as amended? Seeing none, let's get my sheet out. House Bill 824. The Vice Chair. Yes. Delegate Munoz. No. Delegate Crutchfield. Yes. Delegate Cardin. Yes. Delegate Bartlett. Yes. You're welcome. Delegate Embry. Yes. Delegate Pasteur. Yes. Delegate Tolles. Yes. Delegate Schmidt. No. Delegate Simmons is excused, although he is doing quite well. Delegate Boucher. No. Delegate Phillips. Yes. Delegate Tomlinson. No. Delegate Arakan. No. Delegate Taylor. Yes. Delegate Simpson. Yes. Delegate Grammer. No. Delegate Young. Yes. Delegate Valentine. No. Delegate Conaway. Yes. Oh, I forgot that part. Delegate Kaufman. I'll get there. Delegate Kaufman, yes. Hold on. Delegate Kaufman, yes. Delegate Williams. Delegate Williams?
Oh, yes.
Yes. All right. For those people who voted yes, can I see the front page? Do you have it? Oh. Who would like to add on? Who would like to add on, please raise your hands. I'm not sure. If you're not sure, just raise your hands. Put your hand down. You want to go on? All right, Conway is on. Kaufman will go on. And Moon. Who did I just? Oh, Conway. All right. The chair votes aye. Mostly just to ruin David Moon's piece of paper. All right. The bill is moved favorably, 15-7. Okay, everybody, we've got a few other things going on. Why don't we do those for a couple minutes, and then we'll probably have to come back tomorrow. Here we go. So, really? Yeah. We're all on the record publicly when you're saying that, right? All right. House Bill 18, speaking of the devil. Wait a minute, there's amendments. There are many amendments, but I think we adopted the amendments last time. Was there a technical amendment that we needed? Turn on your mic. Turn on your mic.
We had to take out, I'm pulling down, I have to get down to like page 10. We had to pull out, is it page 10? Page 5. We're striking lines 28 through 29. I have a different version up. And it's just about 6 words that referred to a part of the bill that was already stricken, so we just want to take that out so there was no confusion. I would move the technical amendments.
Moves and technical amendments. There's a second. Any questions about the technical amendments? Seeing none. Could I have a motion on the technical amendments? Motion for the amendments. We are on House Bill 18. Second, and all right, great. All in favor of the amendments, raise your hands. Anybody opposed? There's, all right, we're on the bill as amended, and we have a motion and a second for a favorable. Any further discussion on the bill as amended? Seeing none. The Vice Chair. Yes. Delegate Munoz. Yes. Crutchfield. Yes. Cardin. Yes. Bartlett. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons excused. Boucher. Yes. Phillips. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Young. Yes. Valentine. Yes. Sorry. Yes. Conaway. Yes. Kaufman. Yeah, and one, well, wait a minute. Williams.
Yes.
Yes. Do people want to add on? Delegate Kaufman wants to add on? We'll leave it at that. Okay. Moving right along. House Bill 36. Oh dear, is this? There are amendments. Turn on your microphone, please.
Mr. Chair, this bill is the one that requires landlords to be licensed before they can file actions against tenants. The amendments were worked out over the last 5 or 6 days with advocates on all sides. They did come to a peace in the valley. We have provided, do we have the amendments provided to everybody? They've been sent out to everybody. I can give you the essence of it, is that looks like, I'm just going to pull out. Sure, I want to pull out the exact language that they were fighting over, but if you want to do it, you can.
Just clarify that the act doesn't apply to an action to repossess for a breach of lease. A lot of these are just clarifying too. Amendments require the landlord to plead with certain supporting documents when filing the complaint and list out those documents. It provides the landlord demonstrate by preponderance of evidence that the property is licensed properly or exempt. And then it lists out on page 5 exceptions for the landlord, and this is the consensus that all the parties were then okay. On page 5, starting after line 2, it just provides exceptions for multi-unit properties, for example, to certain requirements that are free, certain requirements and when certain units are free from defects, and showing that the condition isn't affecting all units in the building versus just a specific unit in the building. And then they also, the final amendment just allows for postponement for additional evidence, one postponement if it's needed.
We'll take a motion for the amendments. Is there a second? Fine. Then we're on the amendments for discussion. We'll go to Delegate Grammer.
I prefer to talk on the bill, if that's okay.
Are there people who have questions or comments about the amendments? Questions for Holly? Questions for Delegate Cardin? Favorite color? All right, that's fine. Then we'll take a vote on the amendments. All in favor of the amendments, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8. Anybody opposed? No one opposed. So there's a motion for a favorable and a second. Now, Delegate Grammer.
Mr. Chair, just wanted to express frustration again. We have the worst bout of slumlords in the Baltimore region in District 6 that I've seen. The problem's getting worse. We haven't addressed it in the 9 years I've been here. We have hundreds of properties that operate as rentals without licenses. And I know it's not 100% germane here, but I just wanted to reinforce the fact that we have a problem with 99% of the time where a property operates without a license. And instead of addressing that and the real problems associated with that, you know, we're focusing on the very end here, where you have a lot of property owners that are concerned that they're losing their property rights. So I'm not going to raise a huge stink about this. I just wanted to reinforce that it continues to be an issue throughout Baltimore in my district, and it's something that does need attention. Thank you.
Anyone else? All right. Be nice. Be nice. Stop it. Are there further questions? Are you sure? Are you okay? All right, that's fine. Anything else? Seeing none. The Vice Chair? Munoz? No. Crutchfield? Yes. Cardin? Yes. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? No. Simmons is excused. Boucher? No. Phillips? Yes. Tomlinson? No. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? No. Young? Yes. Valentine? No. Conaway? Yes. Kaufman? Yes. And and Williams? Yes. The favorable is adopted, 14-7. Okay. Anybody else want to add on that bill? Conaway? Moon? Conaway? All right. Do you need me? You need this? You got it? Great. Okay. Delegate Moon, 162. The Vice Chair, are there amendments? There are amendments. What do the amendments do, Mr. Vice Chair?
A lot, I guess. Well, they create a process to verify the identity of the people who are putting themselves on this list to not purchase firearms. And the bill originally contemplated the state police would do that, but we now have it arranged so that the Department of Health is going to take ownership of the project more or less and do identity verification with MVA and the Comptroller's office. And that's what you see in the bill.
Let's do this first. You motion for the
Move the amendments.
Is there a second? Fine. Discussion on the amendments. Delegate Conaway.
Amendment. Go ahead. So this is for people to put themselves on the registry voluntarily, right? And then how do they get off of the registry if they want to? That's not sufficient. No, because to get on, you would just get on and say.
No, you have to verify the identity to get on. And then you also request to get off, and then they'll verify again.
What I'm saying is, do you need permission from anyone or any agency once you're on the registry to be taken off the registry? No. Okay, thank you. I want to be clear on that. Can you summarize the amendment?
It makes Maryland Department of Health the responsible agency for developing the application process to get on and off the list. and then it has Department of Health work with the Comptroller's Office and MVA to verify the identity of people who are asking to be put on and taken off the list. Yep. It's a very small bill.
Delegate Munoz.
Thank you, Mr. Chair. So with this change, is this making,
The audio's playing. The video's not. Sorry, Delegate Munoz.
is this change making this registry safer? Are people's identities and the fact that they're on this registry more protected because of this change?
Yes. So just so people understand why these changes are being made, there's some concern from folks that someone may put a third party onto the list because they have a dispute or some reason like that. So A, there's a criminal penalty in the bill up to a year for making a fraudulent application like that. And two, now we're doing this whole verification process. And if you want to know, it's going to look something like an employment verification. You know, 2 forms of address check. Do you have a birth certificate or something with your, you know, this, what you see like on an I-9 employment verification. And if that doesn't work, then they go through the comptroller's office. So they're doing a lot here to try and satisfy everybody.
That's really wonderful. Thank you so much.
On the amendments, further questions on the amendment? Seeing none. On the adoption of the amendments, all in favor of the amendments, raise your hands. Anybody opposed? Okay, it's unanimously adopted. We're on the bill as amended. There's a motion for a favorable and a second. Any further discussion on the bill as amended? Delegate Erican.
So I know I already talked to Delegate Moon earlier about my concerns on the civil litigation piece of it, and I know we're going to try and maybe fine-tune on the Senate side. But just for the record, I want to make sure that I at least state that I do have a concern that, you know, in a spousal divorce situation, custody situation, we could see, you know, a postpartum mother who's put herself on this registry. She's depressed. She thinks she's doing the right thing. And then down the road, when there's a divorce situation, her husband could potentially bring it up and use it against her in a child custody decision. So hopefully we can find a way to create language that prevents a situation like that, because we don't want to discourage people who feel they need to be using this mechanism from using it if they fear the loss of their children 5-10 years down the road because they've volunteered themselves for this list. And so I'm hoping that there's a solution for that down the road. So I'll be in no tonight, but look forward to maybe voting for it if we can tweak that.
Thank you, Mr. Chair. I have one question and one comment. So I really appreciate the verification that you've added to make sure people are who they say they are, as well as the penalty for people doing this unlawfully. Is there any mechanism, or is there someone responsible for ensuring when someone removes themselves from this registry that they are in fact removed?
Well, they're supposed to get a notification both for the application to get on and to get off. So they will be notified that they've been put on or taken off the list.
Okay, and that will come from the Department of Health?
Yep.
Okay, I really appreciate that. And I just want to share, I know many of you know this, but some do not. A dear friend of mine who was the first in our law school class was an amazing young man who was raised by a single mother in poverty and ended up attending the University of Maryland School of Law, getting his dream job in Baltimore City, doing amazing legal work. He struggled. None of us were aware of it. Incredibly liberal, progressive young man, beautiful soul. You will not find a picture of him ever without a giant smile on his face. And a few months ago, he locked himself in his bedroom, wrote a note, took a gun, and shot himself in the head. It was a shock to every single one of us. No one saw it coming. I didn't even know he owned firearms or knew how to use them. And I know that they have this ability to voluntarily, put themselves on these types of lists in more conservative states than Maryland. And so because of my life experience, my friends, and everyone who will come after him, I'll be voting yes today.
All right. We are on the bill as amended. There's been a motion for a favorable and a second. Is there further discussion? Seeing none. The Vice Chair? Yes. Munoz? Yes. Crutchfield? Yes. Cardin? Yes, and an add-on. Bartlett? Yes, and an add-on. Embry? Yes, and an add-on. Oh, no? Oh, sorry. I just was getting rolling.
Peer pressure.
Pasteur? Yes, and an add-on. Tolles? Yes. Schmidt? Yes. Simmons excused. Boucher? No. Phillips? Yes. Tomlinson? No. Erican? No. Taylor? Yes. Simpson? Yes, and an add-on. Grammer? No. Young? Sorry? Yes. Valentine? No. Conaway? Yes, and an add-on. Kaufman? Yes, and an add-on. Williams?
Yes.
If you'd like to explain your vote, go ahead.
Thank you so much, Vice Chair, for bringing this bill. As many know, I represent the city of Hyattsville. And about a year and a half ago, the mayor of Hyattsville, the former mayor of Hyattsville, basically got in his car, drove to a place in Virginia, and blew his brains out with a gun. He was one of not only a constituent, but a really good friend of mine. He was one of the first people who, when I said I was running, endorsed me, did a meet and greet for me at his house. We were the same age. And so if this had been in place, I wonder if he would have used it. So thank you. Thank you so much for bringing this bill forward.
The favorable motion is adopted on the Vice Chair's bill on 162. All right. Taylor is an add-on. Yep. Sure. House Bill 1, yes. Holly is adding you on. House Bill 164, we have to change council, if you don't mind, just because there's a mic, if anybody has any questions. One moment, please. One moment, please. All right, we're changing out counsel. Court's indulgence. Right. Okay. The sponsor offered an amendment to House Bill 164. Claire, did you see the amendment? So if this is a motion for the amendment, again, this limits it to adult offenders only. There's a second? A second. All right. On the amendment or on the bill? On the amendment? On the amendment, Delegate Conaway.
The amendment limits the age of I guess, the younger adult, 16.
The person would only be put on the registry if they committed the crime as an adult.
And
So
they were
if they were
21.
a child, if they were under 18 when they did it, it would not apply.
Right, but if they're over 21,
So you're going to the bill generally as opposed to what the amendment.
the amendment says what?
The amendment just makes it relevant to people who were found convicted of the law when they were 18 and over,
18,
when they were adults, at the time of the offense.
between 18 and 21.
18 and infinity. Yeah.
Okay.
So there's a motion and a second on the amendment. All in favor of the amendment, raise your hands. Anyone opposed? It's a sponsor amendment from Delegate Crosby. And so now we're on the bill. Now we're on the bill, and we'll go to, can I have a motion on the bill? Favorable, is there a second? Second. On the bill, Delegate Conaway.
The amendment that we just made, does that drop the age from 21 to 18?
Is at least 21 years of age. Does not drop that to 18, and Claire can explain more. Claire needs her mic.
Yeah, it doesn't, the amendment doesn't affect that aspect of the bill. That aspect of the bill is for the crime of violence. The amendment only affects the lifetime sexual offender parole, lifetime sexual offender supervision aspect of the bill.
Which is on page what?
Of the bill,
Yeah.
page 4 through 7.
Thank you.
Are there further questions or comments about the legislation, about the bill as amended? Seeing none. There's a motion and a second. The vice chair. Yes. Munoz. Crutchfield. Delegate Cardin. Yes. Bartlett. Yes.
Love the fact, I shouldn't say love, but I am very happy with the amended version. And I think it makes the bill better.
Embry.
Yes.
Yes. Pasteur.
Yes.
Yes. Tolles. Yes. Schmidt. Yes. Simmons is excused. Boucher. Yes. Phillips. Yes. Tomlinson. Yes. Erican. Yes. And yeah, we have an amendment, so yes, she's adding on. Taylor. Yes. Simpson. Yes. Grammer. Yes. Young. Yes. Valentine. Yes. Conaway. Yes. Kaufman. Yes, and adding on. Williams. Yes. We'll go around and do add-ons. Delegate Munoz in the back. Okay, who wants to add on? Delegate Phillips. Philip. I see you, Kaufman. Anybody else? All right. Motion is adopted. We're now on House Bill 287. It's a motion for a favorable and a second. This went to the subcommittee. Which subcommittee? This went to your subcommittee. Went to criminal law. It's regarding eliminating HIV, these HIV-specific crime for the transmission of HIV. There's a motion and a second. We're on the bill as there are no amendments. Any discussion? The Vice Chair.
I just want to be clear before we vote on this, so that everybody understands exactly the state of law here. So, I can't remember what the vote was in subcommittee, to be honest, but this, we debated doing a straight repeal or trying to put something in that says, well, disease, giving people diseases is a crime, and that grammar was barking down that tree, and we decided to go with a straight repeal. But before I get into the very quick policy explanation for it, the very section of code right before this HOV law, already a crime, excuse me.
HOV is slightly
Yes,
different.
excuse me. I just want to make sure everybody understands the remaining existing law if we repeal this HIV crime. Prohibited act, an individual who has an infectious disease that endangers public health may not willfully be in a public place without taking precautions against exposing other individuals to that disease, or transfer to another individual any article that has been exposed to the disease without thoroughly disinfecting the article. Person who violates any provision is guilty of a misdemeanor, $500 or a year. And then the next section goes on to HIV, the only specifically named disease in Maryland law that has its own penalty. So if we repeal the HIV crime, we're not doing away, and there's other assaults that you could likely attempt depending on the facts of the case, okay? And if you don't know the science of HIV now, you're not necessarily transmitting if you're HIV positive due to the miracle of modern medicine and people who take prophylactic.
Further questions
Yes.
of Delegate Conaway?
Mr. Chairman, thank you, Delegate, for explaining this. Is this the bill? Is this the bill where if you ask a person their HIV status, no?
Charged with a crime,
Right.
up to 3 years in prison.
Right.
If you have HIV,
Yes.
and you knowingly transfer or attempt to transfer.
Yes.
Yeah.
Yes, and you played down what I'm talking about by talking about how beautiful modern day medicine is. So therefore, if a person knows that they have HIV, but the beauty of modern day medicine, they have no responsibility to tell you that you could possibly contract HIV.
No,
you
no.
can go down and get rid of that like syphilis and gonorrhea, right? Is that correct?
No, I'm saying there's
okay.
not
I fail to see the beauty of the modern day medicine.
Okay. No, the point is that there's not a specific reason to pull out the one disease and give it its own penalty and crime category. That's the point of the medicine.
Can you say that a different reason or a different way? There's no reason to point at just HIV and say,
Yes.
well, we have.
You don't need to single it out.
HIV.
There's another law. You don't need to single it out.
So in the other law, what does it say?
I just read it. I'll do
can
it
you
again.
read it again? I
An
couldn't hear
individual who has an infectious disease that endangers public health may not willingly be in a public place without taking proper precautions against exposing other individuals.
Right, and I heard what I thought I heard. So you're talking about a public place versus a private place, is that correct?
Or transfer to another individual an article
it
that
could be
is
transferred in a private place. Somebody said, no, that I'm hearing this wrong.
it's public place,
Right.
or transfer through an article in any place.
Right, but if they willingly transfer it through you through sexual contact or whatever, is that under?
I mean, your genitals were probably articles that you have to.
Really?
I mean, I'm just reading the code here. I'm being asked about the existing law.
Right.
I think it's covered. I really do.
I don't think that is covered. If you remove this part, the part that you're talking. Okay. Would the chairman like to chime in?
Yes, I do. Delegate Williams, then Delegate Boucher.
I was going to say,
You can't.
Okay, I was just gonna say, yeah, be careful who you sleep with. And there's lots of other things that I can't just get a shot for. Like if I had herpes, there's no law that would require me to do what it is I think that you're getting at, Delegate Conway.
So how many people die from herpes? Have you ever heard of somebody dying from
No,
herpes?
I
Oh,
have
you have.
not.
Have you ever heard anyone dying from HIV?
With the advent of modern medicine, most people do not die of HIV anymore.
I didn't know that.
Yes, that is correct. And
Yeah,
I
yeah,
actually
yeah.
have a good friend who is HIV positive
Oh, yeah.
and is living a wonderful, beautiful
I
life.
know about Magic Johnson and all that.
I'm not talking about magic. I wish I was
Okay,
friends with
okay,
magic.
okay. We're on the bill. Let's slow it down a little bit. And I'm going to move to Delegate Boucher.
Chairman, without holding up a sign, I move for an affirmative vote.
I think we had a motion for a favorable and a second, and I think that you were trying to move the previous question. You were trying to, but Delegate Grammer has a comment, and then maybe I might enjoy taking that.
Yeah, I
Delegate
won't
Grammer.
belabor this too much, and I think the most important word in the bill here was the knowingly. That was frankly the virus, the communicable disease, the hepatitis, whatever is irrelevant. The word that it was most striking to me, and this bill sponsor agreed with this, was the word knowingly, and that's the culpability standard in the crime. You know you have hepatitis. You have sex because you're horny, despite knowing that you have hepatitis, and you could have prevented this person from contracting it, but you did so knowingly. So, my problem is that we've just lived through a pandemic. We ruined people strictly for not getting a vaccine. I had people in my community threaten to go to church just because the church was threatening to have people in during a COVID the COVID lockdown. And, under the section of code, a person could knowingly commit it. I was more concerned about the broadness of a person who knowingly gives a communicable disease.
Your red covers all of that.
Differently applied. That's why I'm not going to belabor it. I don't have an amendment. I just think, having lived through what we lived through, there is a giant hypocrisy in the way we've let our government operate. If we can shut down churches because we are afraid of a virus, and we don't give people a remedy for knowingly communicating some really serious disease such as hepatitis, I mean, these people have no remedy anymore. So just wanted to make that comment.
So the standard in the law as it would exist is it would be a willful transmission. So I feel like we're that far away. But Delegate Tomlinson.
I was told that there was a amendment, I believe, in subcommittee introduced or proposed. Was that correct? No? Was not?
It was discussed but not proposed. Is that right, Mr. Vice
It
Chair?
was discussed and not proposed, but in the discussion, I mean, exactly what Delegate Grammer is talking about came up. Did we want to be in the business of charging people like the lady who spits COVID and, has, running around coughing on salad bars and things like that? I mean, a lot of that behavior is clearly implicated by what was existing law. And so I guess if you're going to be consistent, the question is whether you think all of those people should have been charged with a jailable crime. I mean, it sounds like, I just can't tell if you're saying that's what we should have done, that all of these diseases should have been charged, disease transmission should have been charged as a crime. And in subcommittee, some of your party mates were not having that and thought that was a very untenable position to put law enforcement in. So that's why we ended up going in the other direction. As you know, you were there. And we said, no, let's just not be in the business of doing this.
I was just trying to ask what that is. That what the talk was to remove the word knowingly? That was my question. No.
Allow prosecution of all disease transmission or just HIV.
Oh, okay.
Yeah.
Okay, gotcha. That was my question.
Delegate Young, and then I think I'm going to hear a motion from Delegate Boucher. Delegate Young.
I got to follow up on Delegate Conway on 18-601A2, transfer to another individual any article that has been exposed to the disease without thoroughly disinfecting the article. I don't necessarily read that to speak to a transmission of a disease within an individual. I read that to speak to an article. This is an article that can be disinfected. I can't disinfect me if I have a disease. I'm not opposed to the bill, and I'm fully in support of the bill. I'm simply saying that the rationale that I don't think that Delegate Conway's concern has been hit, because I just don't think this applies to that. I would ask for clarity on what law does apply in the other circumstances. We referenced other diseases, and we are hanging on the other diseases. Obviously, you can't do those in the same manner.
I was like, look, I was sort of half jokingly talking about transmitting through an unclean article in that section of code. But there are fact specific. You'd have to get very fact specific to get into other things. I mean, reckless endangerment. A person may not recklessly engage in conduct that creates a substantial risk of death or serious physical injury to another. Now, I suppose the purpose of this law 20 years ago, when we didn't have medical treatments for HIV, that's what whoever created that law was arguing was going on. That, I would argue, has changed, but that reckless endangerment law still applies. Whether you could apply it to HIV or not, I don't know. Probably not.
Thank you, Mr. Vice Chair, and I appreciate that explanation. I'm good with that explanation. I just wanted to make sure that we had that out on the record. Thank you.
Delegate Boucher, do you have a motion?
I call for the vote.
Are you moving the previous question?
Move the question.
There's a motion for the previous question. All in favor of moving the previous question, say aye. Opposed, no. We're on the bill as not as amended. Favorable motion on the bill. Seeing discussion is already completed. The Vice Chair, yes. Munoz, Crutchfield, yes. Cardin, yes. Bartlett, yes. Embry, yes. Pasteur, yes. Tolles, We'll come back. Schmidt, no. Simmons is excused. Boucher, yes. Phillips, yes. Tomlinson, no. Erican, no. Taylor, yes. Simpson, yes. Grammer, no. Young, yes. Valentine, no. Conaway, no, and you can explain your vote.
Without medical care, HIV still leads to AIDS and early death. Since the beginning of the epidemic, nearly 6,700 people with AIDS in the United States have died. And even today, nearly 13,000 people with AIDS in the United States die each year. So I appreciate the Vice Chair justing with me. Thank you very much.
Kaufman? Yes. Yes. Williams? Yes. Munoz? No. Tolles? Yes. The chair votes yes. 15-7. Okay. House Bill 336. I'm not sure how much longer we're going to go, but House Bill 336 is up. There are no amendments. There's a motion for a favorable and a second. Any discussion on House Bill 336? Addresses a technical issue in the law. Seeing none. The Vice Chair. Yes. Munoz. Yes. Crutchfield. Yes. Cardin. Yes. Bartlett. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons is excused. Boucher. Yes. Phillips. Yes. Tomlinson. Yes, Erican. Yes, Taylor. Yes, Simpson. Yes, Grammer. Yes, Young. Yes, Valentine. Yes, Conaway. Yes, Kaufman. Yes, Williams. Favorable motion is adopted. House Bill 411. There's a motion for a favorable and a second. Is there a discussion on someone's first bill? Is there lots of critical conversation that we want to have at 9:30 at night? Tomorrow, lots of regrets. Somebody going to use their hold? The trooper was getting upset there. I'll tell you that right now. The trooper was getting upset. All right. Any discussion about the bill? Seeing none. The Vice Chair. Yes. Munoz. Yes. Crutchfield. Yes. Cardin. Yes. Bartlett. Yes. Pay attention. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons is excused. Boucher. Yes. Phillips. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Young. It's bad enough that they won in the men's basketball tournament now against, and I'm now, no, I'm sorry, focus. Valentine, yes. Conaway, yes. Kaufman, yes, for the bill. Williams, Embry, yes. Bill is adopted. The favorable is adopted. Oh, I'm feeling a little generous. No. We're gonna roll with a couple more. We're gonna do 3 more, but you're gonna see that just settle down. House Bill 672, which I believe favorable. Is there a second? I know. Is there a second on House Bill 672? Fine. I did okay. I'm skipping things for a reason. Just bear with me here. You'll see the method to my madness here in a moment. This is someone's first bill, I believe, isn't it? Gee, Delegate Tolles. Everybody take a breath. Any discussion on House Bill 672? Delegate Williams.
So, this bill, it's a good bill.
All right, enough of that. All right. Further discussion. Do you really want to talk on this bill? Do you really want to talk on this bill?
No!
Turn off your mic. Fine. Okay, the Vice Chair. Munoz. Crutchfield. Yes, all 3 yeses. Cardin. Yes. Bartlett. Yes. Embry. Yes. Pasteur. Yes. Schmidt. Yes. Simmons is excused. Boucher. Yes. Phillips. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Okay. Simpson. Yes. Grammer. Yes. Young. Yes. Valentine. Yes. Conaway. Yes. Kaufman. Yes. Williams. Tolles. All right. Move for the favorable. While we're at it, House Bill 747. 747, Delegate Pasteur.
Move favorable. Move favorable.
All right. We're on favorable in a second. Favorable in a second with 747. 747, favorable in a second. It's their discussion on 747. See, Delegate Taylor, do you have a question?
Do the service if they wanted to. I just wanted to know. Okay.
You gotta live with her. So y'all
It's a question.
I just wanted to know. And then, so, did we ever answer
It
that
doesn't
question?
matter that it's her first bill. It's a legitimate question. Delegate Pasteur.
Because I don't get
into other things like working in the industrial whatever, but the agricultural thing, no. Yes, sir.
Further questions or comments?
Close the question.
Oh, my goodness. All right.
It's my seatmate, y'all.
That's right.
All right.
Oh, John, shut up.
I gotta come over there and get you again.
This point that I think we broke the internet again. Are we on? We're coming on. Oh, y'all didn't miss anything at home. All right. We're ready to vote this? Yeah, I think so. The Vice Chair, yes. Munoz, yes. Crutchfield, yes. Cardin, yes. Bartlett, yes. Embry, Tolles, yes. Schmidt, yes. Simmons is excused. Boucher, oui. Phillips, oui. Tomlinson, yes. Erican, yes. Taylor, yes. Simpson, yes. Grammer, yes. Young, yes. Valentine, yes. Conaway, yes. Kaufman, yes. Williams, Pasteur. Yes. Favorable motion is adopted. House Bill 761, Delegate Phillips.
Move favorable.
There's a motion for a favorable in a second. Are you sure? All right. Are there questions on House Bill 761? Delegate Schmidt has a question.
I just want to say this for the record. I am a yes on this bill. My biggest fear is keeping it funded. That's my biggest fear. So if we can work on that in the future. I just want to making sure we have money to pay for it. That's all. Yes. No, not for the chain gang.
Okay. Here we are. Questions, further questions or comments? Seeing none, the Vice Chair, Munoz. Yes. Crutchfield. Yes. Cardin. Yes. Bartlett. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons is excused. Boucher. Yes. Phillips. Oh, damn it, I did the right Damn it. Tomlinson. All sense of drama is destroyed now. Delegate Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Young. Yes. Valentine. Yes. Conaway. Yes. Kaufman. Yes. Williams. You want to vote again? Phillips? Yes! Motion's adopted. All right. Delegate, what were you saying? It's 9:36. You want to knock out the rest?
Yes, let's knock it out.
All right. House Bill 591. House Bill 591. There's a motion for a favorable and a second. What were you saying, Delegate Munoz? What were you saying, Delegate Munoz? This is Delegate Buckles' bill.
Oh, I am contractually obligated to support this bill.
There's a motion for a favorable and a second. Is there further discussion on the bill? Contractually obligated. Okay, any discussion? All right, minority leader is watching. The vice chair, yes. Munoz, are you sure? Yes. Crutchfield, yes. Cardin, yes. Bartlett, yes. Embry, yes. Pasteur, yes. Tolles, yes. Schmidt, yes. Simmons is excused. Boucher, yes. Phillips, yes. Tomlinson, yes. Erican, yes. Taylor, yes. Simpson, yes. Grammer, yes. Young, yes. Valentine, yes. Conaway, yes. Kaufman, yes. Williams, yes. The motion's adopted for a favorable. Let's go now to decanting legislation from Delegate Cardin, House Bill 687. This does not have to do with red wine. Are there amendments? No, there are no amendments. There's a motion for the bill and a second. Okay. Delegate Tolles with a question, then Erican.
Is this the one with the analyst that came in the civil law?
No, this isn't that one.
We already passed that one.
I was going to say no. No, I'm teasing.
Delegate Erican.
Could the good delegate sponsor please just define decanting again for the people that are listening in?
Well, it depends. Do you want wine decanting or this kind of decanting?
No, not wine decanting. I finally gave that up last year. Just this kind of decanting.
Okay. It's about the movement by fiduciary of money from a trust, from one trust to another trust, and making sure it's done in a way that fills the fiduciary duty to make sure that it's the intention of whether it be of the trust or the trustee to make sure it's done properly. How's that for?
Further questions? There's been a motion and a second. We're on the bill. The vice chair? Yes. Munoz? Yes. Crutchfield? Yes. Cardin?
Yes.
Yes. Bartlett? Yes. Embry? Yes. Pasteur? I know. Yes. Tolles? Yes. Schmidt? Yes. Simmons is excused. Boucher? Yes. Phillips? Tomlinson? Yes. Phillips is a yes. Tomlinson's a yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Young? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams. Motion is adopted for a favorable. We hear two bills from Delegate Hill with that have to do with swatting. There's no amendments. For House Bill 744. There's a motion for a favorable and a second. Is there further discussion on House Bill 744? Sorry? He's taking pictures. Okay, I can't.
I'm getting ready to defend HIV on the floor now.
You can't get the books anywhere else, really, so it's important. Okay, focus. There are different words here. Any further discussion? See, I know. That's fine. It's terrifying. All right, the vice chair. Yes. Munoz. Yes. Crutchfield. Yes. Cardin. Yes. Bartlett. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Boucher. Yes. Phillips. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Young. Yes. Valentine. Yes. Conaway. Yes. Kaufman. Yes. Williams. Yes. Motion is adopted. Now we're on 745, a motion for a favorable and a second. This is the second of the two-part series. Delegate Kaufman.
I just would like to say that the Jewish community has been a major victim of of swatting, and that is why you saw the ADL come out and strongly in favor of it, and the BJC and other organizations. So I thank Delegate Hill for introducing this. I think it's going to be an important tool for law enforcement.
Further discussion? No? Okay. The Vice Chair. Munoz. Yes. Crutchfield? Yes. Cardin? Yes. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Boucher? Yes. Phillips? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Young? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams? Yes. Motion is adopted. And now the last bill on the list.
Move favorable.
There's a motion for a favorable on House Bill 749 and a second. She has survived COVID. Will she survive this vote? It's a little ominous, actually. I didn't really mean it that way. Are there questions about House Bill 749? No? Well, then I suppose we should vote on it. The Vice Chair, yes. Munoz, yes. Crutchfield, yes. Cardin, yes. Bartlett, yes. Embry, yes. Pasteur, yes. Tolles, yes. Schmidt, yes. Boucher, yes. Phillips, yes. Tomlinson, yes. Erican, yes. Taylor, yes. Simpson, yes. Grammer, yes. Young, yes. Valentine, yes. Conaway, yes. Kaufman, yes. Williams, yes. Okay, so hold on a second. Any subcommittee announcements? I don't think there are there?
We are.
Do we have criminal criminal laws meeting tomorrow?
And I have no idea when we're going to be able to.
So I'm going to ask everybody to pay attention on the floor. There'll be some thirds probably tomorrow, so I'm not sure how long the floor session will go. Obviously, I think the marijuana reform bill is going to be Friday. I do not foresee us voting tomorrow. I, at the moment, do not foresee us, because we got this done, voting on Friday. However, I'm going to still leave it as a possibility, because there are other bills that are floating through subcommittee, and we're at the point in session where we have to try and, if it's going to pass, we're going to try and get it out. With that, thank you all very much, and we are adjourned.